There was some question as to what I was doing in that law library video the other day. And what I was doing is I was giving you a little insight into the world of how a law library works, while at the same time I was smacking down Mr. Cates and his attempt at stating without showing that the Ninth Amendment somehow enshrines a right to self defense against arrest or unlawful arrest. So what I found, so what I did is I went in there and I went to the U.S. Code Annotated. It's a Westlaw version, and I went to the Ninth Amendment. I pulled the Ninth Amendment book. I flipped open to the Ninth Amendment portion of that book, and then I read through the little subcategories. What those annotated codes do is they break down the different types of cases that are based on that amendment. And for the Ninth Amendment providing a right to self defense, I found this case, White v. Arn. And in White v. Arn, it very specifically goes over a constitutional right to self defense. The fact pattern isn't really important in this particular instance because of the way the court addressed it. White asserts two additional arguments. She contends there is a constitutional right of self-defense founded in the 8th, Ninth, and 14th Amendment, which an accused cannot be required to prove. We decline to adopt this notion. In Patterson, the Supreme Court enunciated the proper analysis for determining the constitutionality of the allocation of the burden of proving affirmative defenses. That analysis is the correct way to resolve the present issue. For this court to hold that self-defense is a constitutional right, which the defendant cannot constitutionally be required to prove, would be to reject the Supreme Court's established analysis and dispose of the case on a novel, unaccepted theory. So, this we decline to do. Rather, we adhere to the Patterson elements analysis in deciding this case. As stated above, that analysis dictates that White's due process rights were not violated. So there is not a constitutional right to self-defense, or at least not a constitutional right to self-defense from the 8th, Ninth, and 14th Amendment that allow you to resist arrest. To further eliminate Mr. Cates' objection to my statements on the right or lack thereof to resist arrest in Texas, this is United States v. DeRay. You'll see that it has a big red stop sign up here. This case is no longer good law, but this is a case that people have tried to use to establish a constitutional or some otherwise substantive right to self-defense. The fact pattern, again, isn't really interesting, but in this case, there actually was no resistance. The person who they arrested went along willingly, and the government tried to show that that proved that the police had probable cause, because obviously if they didn't have probable cause, if the guy was innocent, he would have protested his arrest. He wouldn't have been silent and just gone along with it. He would have protested his arrest. The government also makes, and several times repeats, an argument to the effect that the officers could infer probable cause from the fact that DeRay did not protest his arrest, did not at once assert his innocence, and silently accepted the command to go along to the police station. One has an undoubted right to resist an unlawful arrest, and the courts will uphold that right of resistance in proper cases. Ooh, sounds like a slam dunk, right? This is dicta. And this case is no longer good law. You combine that with John Badilk v. the United States, you'll notice again the big red warning arrow. All over LexisNexis, it says that this has been overturned by statute. So there you go. There are, I believe, 5 cases that directly state that John Bad Elk is no longer good law. There's, I believe, 6 cases that call into question the ruling. And then there are the statutes which have overruled the basis, the common law basis that this was ruled on. So this is, you cannot make a case any more dead than John Bad Elk. It is a dead case. And then completely and entirely on point is Villafranca versus the United States. You'll notice this is from the Northern District of Texas. You can't get more on point than this. There are more recent cases than this which directly address John Bad Elk and D. Ray. Mostly they address it by citing Villafranca, though, so it doesn't really make that much sense to go over them. And considering this is entirely on point, we're going to stop here on it. But this is Villafranca versus the United States. This is not a 1983 lawsuit. He actually went under the Federal Tort Claims Act because you can go after the U.S. for assault committed by law enforcement officers under the Federal Tort Claims Act. So that's the theory they went under. Mr. Villafranca, he didn't do a whole lot. The agents ordered him to place his hands behind his back. They intended to search him, and he initially complied with the order. But as the agent grabbed Villafranca's hands, Villafranca jerked his arm away from the DEA agent and quickly moved away. That was the resistance. It sounds terrible. Terrible! And they address it here. By jerking his arm away from one of the DEA agents and by struggling against DEA agent's efforts to handcuff him, Villafranca committed the crime of resisting search and arrest. And a person who uses force in order to shake off an officer's detaining grip, whether by pushing or pulling, may be guilty of resisting arrest under 3803, footnote 3. Footnote 3 says, although Villafranca cites 2 old Supreme Court cases making passing reference to some type of right to resist an unlawful arrest, C. DeRay and Bad Elk, it is now clearly established under Texas law that it is no defense to resisting arrest and or search that the arrest or search was unlawful. So it is dead. It is done. Put a fork in it. You can keep arguing it, I guess, but there's really no point in it. It is dead law. So thank you very much for watching. If ever you have any questions that I don't answer, I've shown you how to use the law library. I'll probably film myself doing that again at some point in time so you can continue to get an idea. My particular law library isn't very awesome. It's very small. It doesn't have a lot of things in it that I would like for it to have, but it still suits the purpose. Thanks for watching. Have a great day.